terms of what your plans are for the future, and it has to do with the compliance with the provisions of Prop 1A. And in particular, I want to point out the fact that Prop 1A puts a number of pretty stringent restrictions on how high-speed rail bond funds can be used for construction and when it can be used for construction. And in particular, it requires that before you start using the bond funds, you have to be able to show you have enough funds to complete the segment, a usable segment. And you also have to show that if you're going to put a segment into operation, that it's not going to require a subsidy, an operating subsidy. And it doesn't matter whether it's High-Speed Rail Authority itself that's running it or whether you sort of allow someone else to run it for you, because under the bond measure, it has to be not have a subsidy if it's being run by the authority or under the authority's authority. And under the law that set up the High-Speed Rail Authority, any high-speed rail operation, anything rail operation operating at over 125 miles an hour has to be done by the authorization of the High-Speed Rail Authority. So if it's being done in California and it's high-speed rail, it's being run by the authority. So I just wanted to point those out because they are concerns in terms of some of the discussion about using high-speed rail money, bond funds, to make improvements to conventional commuter rail. Thank you.
Thank you, Mr. Blackman.